Hi everyone, welcome to chapter 18, the criminal trial, and our last chapter for this course. So again, chapter 18 is all about criminal trials, and so this gives you a brief introduction to the whole issue of trial by jury. So the first thing to note is that less than 10% of all cases even go to trial. The vast majority of them are subject to plea bargaining, so people agree prior to trial. In a lot of jurisdictions, it's even higher than 90%, and it'll be like 95% plea bargain out. And if you remember from the chapter 17 lecture we did, this plea bargaining process is really important because the whole entire criminal justice system would collapse if everyone who was charged with a crime actually had a trial by jury. So interesting when you compare that to the fact that we all have a right to a trial by a jury. This comes from the Magna Carta, which was signed in 1215, and it's a really interesting document. I'd like to know more about it, actually. It gives a whole bunch of rights, and one of those, and one of the most important ones, is a right to trial by jury. And the reason why is because in feudal England, a lot of times the kings would just do whatever they wanted to do. And they claimed that the authority to do that came from God. And it used to be that people believed that people with royal blood were closer to God than the serfs. So whatever they said was whatever the law was. So if they wanted to convict somebody of a crime, they'd convict somebody of a crime. But the Magna Carta changed that because now people have rights and it limits the power of kings. I don't know, it's very interesting. So it's one of the most famous documents in the world. And trial by jury came from that, and it became slowly part of the common law, which is how we got that here in America, because we are not England. I know that we used to be part of England, but that document gave the idea, but the actual right to trial by jury is something that was established through judge-made common law. So the constitutional rights relevant to Chapter 18, most are found in the Sixth Amendment, and that gives the right to a speedy and a public trial. So you have a right to a trial by a jury of your peers, and you also have a right that that trial proceed in a speedy fashion, especially if you are detained, haven't been given bail. Also is the right to confront witnesses and assistance of counsel. All of this falls under the general Sixth Amendment rights. The right to confront witnesses also includes the right to subpoena people. So if you've ever been subpoenaed to appear before a court, you know what I mean. So if you happen to witness a crime, you can be compelled to go to court, and of course if you don't answer that subpoena, then you can get criminal sanctions. So the Sixth Amendment also includes the right to make other people testify on your behalf. So the right to trial by jury is a very important right. And one example of that is the Scott Peterson case. I actually remember this from when it was going on. It wasn't really that long ago. But nobody could find Laci Peterson, and she was pregnant. She was just getting ready to have the baby, and all of a sudden she disappeared. And slowly people started suspecting Scott Peterson, but it was hard to convict him because they didn't have a body. So for a long time, the media just, went back and forth and back and forth. Where's Lacey? Where's Lacey? And I think actually we talked about this earlier. This case was a good example of, the need to find a body in a murder case is very hard to convict somebody without one. So anyway, what happened is that this extensive media coverage ended up kind of convicting him in the media. So before the trial happened, a lot of people thought Peterson was already guilty. So he filed a motion for a change of venue. Now, if he gets to a different venue, perhaps the coverage won't be as extensive there, but one of the questions that this case raises is it even possible to find a jury that hasn't been watching the news? Because when it reaches national coverage, that's pretty much everyone. And it also raises issues about, what it means to be impartial. I mean, can you see the footage in the media and still be impartial? People will argue both sides of that. Anyway, you have a right to an impartial jury, and oftentimes people will file a motion for change of venue when there's national media attention, trying to escape that. It also happened in the OJ trial as well. So there's a series of decisions outlining the right to a jury trial. Basically, a jury trial is a trial with a judge and a impaneled jury, whereas a bench trial is a trial with just the judge. And one of the issues is, does that Sixth Amendment right to a jury trial extend to every criminal charge? And we've already learned that it doesn't. For these misdemeanors, a lot of states do not give you a right to jury trial. Also, a right to a jury trial does not extend to juveniles. So that's MacGyver, but you don't need to know. You don't need to know the case, but I just like that name. If you don't know that name, look up the TV show. It's great. It's from like the 80s or something. Anyway, juveniles do not have a right to a jury trial. Also, if the punishment is more than 6 months in prison, then you do have a right to a jury trial. What if it's multiple petty charges? Maybe those, if you put them all together, the person could get 6 months imprisonment. But even if that were the case, there's no right to a trial by jury. So as you can see, a bunch of common law decisions are limiting that right to all these instances where you don't have the right to a jury. And I think the biggest reason behind this is just building an efficient system. For example, juveniles don't have the right to a jury trial. The vast majority of crimes, especially petty offenses, are committed by people who are under the age of 18. So failing to extend the right to a jury trial to those juveniles actually really opens up the system. And also these other ones, petty charges, whether it's 6 months in prison or multiple petty charges, the bulk of people who get in trouble with the law fall into these three categories that I just listed. So not giving them a right to a trial by jury really eases the caseload in our trial courts. Okay, our next issue is jury selection. So federal law requires 12 jurors. State laws, some require 12 jurors, for example, in a capital trial, but a lot of them use at least 6 jurors. The basic qualifications to be on a jury is you have to be 18 years of age or older, and you have to be a registered voter. In fact, voting registration is how they find you. There's often a lot of exceptions. So people have been able to get out of jury service because they're doctors, because they're teachers, because they're lawyers, because they have, important jobs where people rely on them. But those kind of exceptions are not as possible today as they were, say, 15 years ago, because a lot of people have challenged that. You don't have a fair cross-section of the community if you are allowing people with professional jobs to not serve on a jury. So a lot of states limit the exceptions to serving on a jury. Okay, next issue is voir dire. It's a fun word to say. It means technically to speak the truth, voir dire. And it's the process of picking the jury. So the process of picking the jury, or voir dire, is done so that you have a fair and impartial jury. So that's what really voir dire is all about, getting a fair verdict, which the law assumes you get if you have an impaneled group of, say, 12 people that are chosen without, arbitrary criteria and, without their own personal prejudices, which leads me to the issue of peremptory challenges. So a lawyer can challenge a particular jury member who they think, based on something about them, that they might not be objective in the case. For example, if it's an assault with a deadly weapon and the accused is charged with assault with a deadly weapon, and there are jurors who have themselves been victimized by being assaulted with a deadly weapon, maybe by somebody who might have looked like the defendant even, is that person going to be able to be impartial? Is it going to make it more or less likely that they're going to want to convict that person? These are the kinds of things that peremptory challenges attempt to solve. But that example also shows you how peremptory challenges can also be used to exclude somebody based on race or gender. Using gender as the example, the vast majority of people who commit assaults with deadly weapons are male. So, especially if that assault is, somebody who is not in a relationship. So women, when they assault, they're often they're more likely to assault somebody who they are in a relationship with. Men do as well, but they also assault people they don't know as well. Anyway, my point is that being assaulted by somebody could give you an issue with gender. So if you're not a male and someone who's male assaults you, you may have a problem with men later, especially men who are carrying guns. So, people may develop biases based on race or gender, and lawyers know that, and they may want to exclude people based on a simple fact of race or gender. So, excluding women from the jury, may help the lawyer to get rid of somebody who might be more likely to convict. But unfortunately, the law says that you cannot do this. So the case to remember about race and jury selection is Batson versus Kentucky. So In this case, the Supreme Court held that you can't exclude people from a jury because of their race. So what happened is Batson, who was African American, was tried for burglary and receiving stolen goods. The prosecution struck all the African American jurors from the jury using peremptory challenge. So it was pretty clear, if you look at it, that the prosecution was striking those jurors because of their race. The court decided, well, you can't do that. Taking these jurors off because of their race denies the defendant a fair trial. And it's kind of interesting that the court decided this, because what they are doing is they are explicitly recognizing that people think differently based on their race, and they've made the same statements about gender. So the idea that, people do approach life differently because of their race or gender, but also people approach a defendant differently if the defendant is like them or dislike them. So the court is recognizing both of those things. But in this case, it was much more obvious what the prosecution was doing. What about when you strike somebody who happens to be African American, but for other reasons? It's the judge that decides whether or not something was racially motivated. So there's a lot of discretion involved in that. But yet, Batson versus Kentucky stands for the rule that you cannot exclude people because of their race. What about when the trial is a capital case? So capital cases are those cases where, if convicted, the defendant could face the death penalty. So that involves what we call the death qualification of the jury. So jurors who oppose the death penalty or have scruples about returning a verdict of death can be excluded from the jury. Why? Because they have to be impartial. And there are a lot of people who do not believe in the death penalty and will not, no matter the circumstances, vote to put somebody to death. So in that case, the person could be disqualified from the jury, because you're going to end up with a hung jury on sentencing if you have a person like that on the jury and everyone else thinks that the person should be sentenced to death. So what's going to happen? So Witherspoon versus Illinois, there's a lot of people, like I said, that oppose capital punishment. I'm one of those people. And just the fact that you oppose the death penalty isn't enough. It has to be that you cannot make an impartial decision. So would you be able to return a verdict for death even if you are personally opposed to it? That is the way that this is normally decided. This is just a snapshot of some of the difficulties that come up with a jury voir dire. Qualifying a jury and selecting the members to impanel a jury takes a very long time. There are the peremptory challenges, and each lawyer may have up to 15 of those. And there's also challenges for cause. So jury selection takes a very long time. Once the jury is impaneled, how do you make sure that that jury is insulated from any prejudice? Well, one of the first things is the rule that jurors may not discuss the case with anyone. And if you're ever impaneled on a jury, you'll learn this, that you have to wear your jury badge in the court. And nobody is supposed to talk to you. So the lawyers, the defendant, the prosecutor, like none of those people are supposed to talk to you because of this rule that jurors cannot discuss the case with anyone. In some longer cases, or cases where there's a lot of media coverage, the jury can be sequestered. So this is very inconvenient, by the way. There's a jury is sequestered, meaning that they don't go home, they don't see their families, they stay in a hotel room as the trial goes on, and some trials can take a very long time. There's also the issue about cameras. In the late 1970s, Florida started allowing cameras, and that's why court TV, you always see these Florida cases. And one of the things actually that made that Zimmerman case such a big deal is that, with the cameras, the fact that it happened in Florida, the television and the media could follow it closely. So there's there's the issues of the freedom of the press, and there's also that many of these trials are high profile trials that people are very interested in. So there's a lot of reason to allow cameras in the courtroom, but by doing that, it makes it much more difficult to insulate the juries from prejudice. Example is the Sam Shepard case. So Sam Shepard was convicted of murdering his wife. It was a grisly murder, and it got insane media coverage. I guess, not much else going on in Ohio, and all they did was talk about Dr. Sam Shepard. Basically, he was convicted in the media on very circumstantial evidence. I think that it was just, the murder was, we see them on these television shows. Like, I've been watching Criminal Minds lately, and they have show after show after show with these murders, but actually those murders happen, they're very, very rare. It's very rare that they happen in real life. And when it does, it makes people a little bit crazy. So the media coverage is always insane. So anyway, the conviction was overturned. And the specific reason that it was overturned was because the sheriff visited the jurors in their motel room. So the juries were not insulated from prejudice. And, after the Shepard case, that's why juries have to always wear their tags. That's why nobody can talk to a juror. There's a question about, whether or not that, actually results in fairness, or whether or not somebody is still convicted in the media. But it is a bright line rule. Case, so now we're not in Ohio but in Nebraska, and another case where there was just this horrific crime, and like I said, these kind of grisly murders are actually extremely rare when they do happen, and one can easily predict the problems with media coverage that's going to happen. So can a court issue a gag order to protect the fairness of the trial? So Nebraska Press obviously is very upset about the fact that they are not allowed to discuss the trial. They say that a gag order violated the First Amendment, but the Supreme Court disagreed because in cases where it is likely that the media coverage will impinge on the fairness of the trial, it is okay to have a gag order. So Nebraska Press is about gag orders. So now we get into the actual trial itself. I'm sure all of you know this already, but the power of a judge in the court is that they keep order. They do this through what we call contempt. So if somebody in the courtroom is unruly, this can be a defendant. It also can be, a spectator that refuses to leave or, starts yelling or whatever. They can be held in contempt. And the power of contempt that judges have is the power to punish someone who flouts court authority. It's not really like on TV. TV makes these things overly dramatic where lawyers are saying, incorrect things and trying to upset people. And actually the way trials run is, they're a lot more subdued. So we don't see contempt being used the same way. But occasionally it does happen. Most likely it will happen because of an unruly defendant. So it's the lawyers behave more in real life than they do on television, I guess I'm saying. So judges have the ability to hold people in contempt. Judges also apply the rules of evidence. So someone's guilt or innocence is based on evidence. That evidence can be verbal statements, it can be writings, documents, photographs. It also can be a person who gets up on the stand and testifies. All of these things are evidence. And there are various rules. The book on, rules of evidence is like 800 pages long. So there's tons of rules about the situations and, moments where this or that can or can't be admitted as evidence. They also change by jurisdiction, so different states are different. But the overall arc of, the rules of evidence is that, specific things relevant to the case are admitted as evidence based upon these rules. The judge can also take judicial notice. So you need to know what judicial notice is. It's something that is, in the common knowledge. So the judge, for example, can take judicial notice of the fact that it was raining on July 15th. Let's say that's relevant. They don't have to bring somebody up on the stand. They can just, anybody can look up, the weather or what the weather was on a particular day. These are the kinds of things that judges take judicial notice of. Once evidence has been admitted, whether or not that evidence proves guilt is the standard of reasonable doubt. There's also lots of rules about whether evidence is relevant or irrelevant. For example, one thing that can happen is that a judge can bring in evidence in a trial on a specific thing, but then tell the jury that they can only consider that evidence with respect to whether a defendant was in place A or B or something like that. So it can limit how they can weigh that evidence. So whether or not the defendant was in love with the victim or whatever, they can't use the evidence for that, but they can use it for this other part of the case. So the rules of relevance is what defines that. So like I said, the rules of evidence is a very, very large book. There's tons of them. But this is the general arc of how the rules of evidence work. Some specific rules that we talk about are the similar fact evidence, and then we also talk about how evidence is classified. So, like I said, evidence has to be relevant. It has to have what we call probative value. So, if it doesn't have anything to do with the case, it's not going to be admitted into evidence because it's not relevant. It depends on the purpose. So evidence can be brought in relative to somebody's motive, like why they wanted to do something, but not whether or not they did it. There's a lot of rules, and the similar fact evidence refers to evidence that is similar to facts alleged in the crime charged. So it has to be relevant to the state of facts of the crime. And each crime has elements. Were you in the place where the victim was? That if the evidence is similar to that fact, it can be admitted. Okay, classification of evidence. There are things like real evidence, so that would be like blood or something like that. And direct evidence that goes directly to proving an element of the crime. For example, I saw Jimmy stabbing Sally, or I saw Dick stabbing Jane. Maybe should use that one instead. But that's direct evidence that goes direct to proving the crime. Indirect evidence involves inference, such as I saw Dick running away from Jane, who was lying on the ground and had just been stabbed. So we didn't see him do it, but the fact that he's running away involves an inference that he's probably guilty. Most of the time, the evidence is indirect. So what about expert witnesses? You can have a regular witness, we call them lay witnesses, that testify to what they saw or heard or whatever. But expert witnesses testify to scientific knowledge that is somehow relevant to the case. The general term that we call all of these people is forensic experts. So these are scientific experts that can testify to some sort of forensic evidence. Two very common ones are medical experts. For example, the medical examiner will testify to, an autopsy that they did on a body, or a handwriting expert that will testify to whether or not a particular sample of handwriting came from a particular person. But these are just two common examples. There are many, many different specialties. You can have an expert in just about anything. If one of the parties wants to call an expert witness, that person has to be qualified. Qualifying an expert witness means looking at their credentials and making a judgment about whether or not that person is an expert in that particular field. Once they have been qualified, an expert gives testimony and is subject to cross-examination. And this cross-examination is, just like any other witness. However, with the expert witnesses, oftentimes you have a cross-examination that also goes to their qualification. So, you bought your degree online, you didn't really get it. So yeah, it could be very stressful to be an expert witness. Hey, here's an example of an expert witness. And what I want you to get out of this here is that qualifying an expert witness is really important. And this is because juries have a tendency to kind of blindly accept science. So if a scientist gets up, especially if they're dressed in a scientific way, and testifies to something, a jury tends to believe what that person says because they think, well, I'm not an expert in psychology, or I'm not an expert in fingerprinting or handwriting or whatever. So there's a tendency, not for juries, just juries, but for people in general, to blindly accept science. But what we know as scientists is that The scientific process is fallible. So just because a scientist makes a claim doesn't mean that it's true. So qualification is the very important role that courts have of making sure that random scientists don't just get up and say random things. Now we get to the issue of Dr. Richard Coons, also known as Dr. Death. So this guy testified at over 150 capital trials, and he predicted in pretty much every single one of them that the defendant posed a future risk to the community. So using his vast scientific knowledge and ability to predict somebody's future behavior, this scientist says, well, this person is, I can tell because of, insert jargon here, mumbo jumbo, I can tell because of all this stuff that this person is going to risk to the community. They must be stopped. So because of his testimony, a lot of people got the death sentence. So then you think about, well, what is this person really saying? And, what if you know that he's paid to testify? A lot of times people will be paid something like $4,000 to testify in a case. That's a lot of money. If I testify in just a couple of cases each year, I can make a decent living just by testifying alone. So if I want to, build a good clientele with, prosecutors, I will come and I'll say that the person poses a risk. Why? Because the person who's paying me, that's what they want me to say. If somebody pays me $4,000 to say somebody's a risk, sure, that's what Dr. Coons did. And because of that, we had a lot of people sentenced to death. So I'm not saying that he was necessarily wrong. Maybe they were all dangers, we don't know that. But the way the system is set up, it's really kind of set up to pay somebody in order to testify for the prosecution. Are you in fact paying for them to say, to have a particular scientific opinion? So this is why qualification is so important, because of people like Dr. Richard Coons. So the evidence that this expert presents, the scientific evidence, how do we know that it is actually real evidence? Well, as I mentioned before, we qualify the witness who explains that evidence to the court. But in addition, there's the evidence itself. So let's say we have now an expert that is interpreting blood evidence. Well, how was that evidence collected? And when it comes to forensic evidence, that's constantly changing. And all you need to do is think about DNA evidence to know what I'm talking about, because DNA evidence completely revolutionized the way that criminal justice goes about, because now you leave cells, you leave DNA, people can trace that specifically to you. So how did DNA come about being accepted in a court? Basically, if something is tested or it's peer-reviewed with a scientifically valid methodology, if all of those things exist, something has passed the, quote, Fry test, or the general acceptance test. So courts will not admit scientific evidence when it's very, very new. So when DNA results first came about, they weren't readily admitted into courts as easily as now. And that's because now DNA evidence is generally accepted. So I want you to know the Fry test. And then some specific examples on this slide, like polygraphs or hypnosis or battered women syndrome. These are all examples to show you about some of the issues with scientific evidence. So polygraphs and hypnosis, the trend with these is to not allow them. And this is because of the general acceptance test. You know, how scientifically valid is a polygraph. And in general, people think polygraphs are suggestive of whether somebody's telling the truth or not. But they're really, you can beat a polygraph. They're not always right because they measure, electrical conductivity. They don't measure the content of your thoughts. So there are a lot of ways, evidence we have, and police generally use polygraphs. They're, commonly used in a lot of settings, but they are not actually admitted as evidence of guilt. Another issue with scientific evidence is the battered women syndrome. And what's interesting about this is that it is a psychological syndrome. You can also make the same exact argument about post-traumatic stress disorder and combat war veterans. But with each of these, as our knowledge of psychology and psychiatric conditions, as that knowledge presses forward, we start to understand how people respond to life or death situations. And people do not think in a linear way because humans are, we're guided much more by our emotions than the courts like to think. So battered women syndrome has successfully shown that people can have an experience, like a fearful experience, that then becomes part of their state of being, so that they may lash out, 2 days from now or 2 weeks from now, responding to what happened today. So anyway, all of these show that scientific evidence is constantly evolving. It has to pass the Fry test. There are some things that generally have not passed it, like polygraphs or hypnosis, and there are other things like battered women syndrome or DNA evidence that, as they become more commonplace, have become accepted. Okay, as a trial proceeds, another thing to talk about is the actual way that the back and forth happens. And somebody takes the stand, somebody has the floor, so to speak, in order to ask questions, while someone on the stand answers questions. But the other people get to talk by making objections. So objections are commonplace in a courtroom setting, and you can make general or specific objections. You don't need to know all of these different objections because there really are just so many of them. Like I said, the Rules of Evidence is a very large book. But here are the common ones. So hearsay is testimony by a witness that as to things that the witness has heard from others. So, when I walked into class this morning, somebody told me that the air conditioning was on in another classroom. I cannot testify to the fact that the air conditioning was on because I heard it from someone else who either was there or maybe they heard it from somewhere else. So hearsay is a way of making sure that gossip does not end up in a courtroom. Doesn't mean that the air conditioning wasn't on, it just means that somebody else who was actually present in that room is the person who needs to testify about it. So I do want you to know the hearsay objection because it's so common, and just knowing it is good for understanding, how a trial progresses if you ever do witness one. But the other ones that you don't need to know, like whether You can object because a expert isn't qualified. You can object because something isn't the best evidence to prove a particular fact. You can object because somebody's giving their opinion instead of testifying about facts. Those are all great, but the one that I want you to know on this slide, the most important one, is the hearsay. You cannot testify unless you're testifying to something that you observed. Of course, there are many exceptions to this rule, though. Okay, so now we get to our last slide on the rules of evidence, and that is privileged communications. So a privileged communication is a communication between the defendant and some other person. That could be a written communication, or it could be something that was said, but that cannot become evidence in a court proceeding because there are certain relationships that privacy of those relationships needs to be protected. For example, attorney-client. I have to, in order to be well represented by my attorney, I have to be able to tell them the truth without worrying. So that means if I did it, I can go up to my attorney and say, I did it. And then the prosecutor cannot call my attorney to the stand to testify to the fact that I did it. That would distort the fairness of the trial. So I can tell my attorney whatever I want without worrying about whether or not I'm going to get in trouble for that. Same thing with the marital privilege. I can tell my spouse whatever I want without worrying about whether or not he or she is going to get called to testify in court about that. So the purpose of this is to preserve domestic harmony, or the sanctity of marriage. That if two people are married, we want them to be able to confide in each other. So that means that I cannot be called to the stand to testify about what my partner has done, because if a court does that, if they compel somebody to testify, they are going to rip apart that marriage and rip apart that family. So married people have a privilege. If you commit a murder and tell your wife about it, do not get divorced, because if you get divorced, you no longer have that privilege. Others, the doctor-patient privilege and the clergy-penitent privilege, so you can tell your priest anything, just like you can tell your doctor anything. So these are privileged communications, and when you make them, they are private. Okay, so now we have done the setup of the trial and the right to jury, and issues with impaneling a jury. Then we have talked about various rules of evidence in the courtroom. So there's the hearsay rule, there's all these privileges that we just talked about now, there's the different kinds of evidence, and that includes expert witnesses. Now we're going to talk about the trial process itself. So how does a criminal trial work? What are the mechanics of a criminal trial? Basically, these trials work with a game analogy. So to be a successful judge, lawyer, or even to be a successful defendant, the best thing to do is to think of the law as a game. And now I know a lot of people don't think of the law this way, but this is how the trials are actually structured. So the judge serves as an umpire, and you have the prosecution team and the defense team, and they are battling it out, and somebody takes the crown at the end through a conviction or an acquittal or whatever. So the judge is like an umpire who rules whether or not the ball was fair or foul, rules on motions, whether something is admissible, inadmissible, tells the jury how they are supposed to rate the game. So it's also like a competition where people get rated, but it's a game, it's explicitly a game analogy. And in order to preserve fairness, lawyers are told they must zealously advocate for their client. And if both the prosecution and the defense are equally equipped and both of them try hard, the idea is that the best team will win. So trials start with the opening statement. The prosecution and the defense both get up in front of the jury and outline what their theory of the case is going to be. So it's followed by, a bunch of, statements of this person did this, that person did that, but all of those are just kind of random factoids thrown out into the universe. It is this opening statement that coheres that into a unified story or theory of the case. So sometimes the defense defers the opening statement, and they'll do this sometimes when they're not quite sure what the prosecution has or how they're going to prepare their defense. But this is the opportunity that both have in order to tell their stories. There's also a closing statement, so this is where they get to do the same thing again. Now they get to remind the jury of their theory of the case in the closing statement, and then how the evidence related to that. So the opening statement provides the theory. Then the prosecution and defense call witnesses, and the prosecution goes first. So they bring up all of their witnesses and they get cross-examined, subject to the Sixth Amendment. And then the prosecution rests their case. And after the prosecution rests their case and brings all their witnesses and presents all their evidence, then it's the defense's turn. So the defense then gets to present their side of the case. Although sometimes what they will do is, instead of getting up to present their evidence, they will move for a judgment of acquittal. They will say, we don't even have to defend ourselves because they have not proved their case. A judgment of acquittal or a directed verdict is, these are synonyms, by the way, judgment of acquittal and directed verdict, they're the same. That's where a judge says that, you know what, no reasonable jury could ever convict this person. There's no way anyone could ever find that they have presented enough evidence to convict beyond a reasonable doubt. And so they will say, as a matter of law, you cannot convict somebody with no evidence, or, they'll say, we have, no direct evidence, and the only indirect evidence is they thought maybe so-and-so did it. In that case, if all the prosecution has is they put a witness who, is sure that so-and-so is guilty because, it came to them in a dream, let's say, a judge would probably move for a directed verdict because no reasonable person would convict somebody based on that. Then the defense doesn't even have to provide their side of the case. But if they don't get a directed verdict, then the defense has to go up and they do the same thing all over again. So just like the prosecution, they will call their own witnesses, and then the prosecution will have the right to confront and cross-examine those witnesses. And then when the defense is all done, the defense will close their case. So one of the issues with a criminal trial is whether or not the defendant actually takes the stand. This is a strategic decision because a defendant does not have to testify. They may testify if they like, but they don't have to. And the jury is not allowed to use the fact that they didn't testify against them. So part of the way the jury is instructed by the judge is they're instructed that they are not allowed to take the failure to testify as an admission of guilt. So after all of this, so the defendant has chosen to take the stand or not take the stand. There is a chance that the prosecution may ask for a rebuttal witness. So this is the right to dispute evidence. So if the defense now presents a new criminal theory that the prosecution didn't know about, they have a right to present their own witnesses to rebut what those witnesses have said. It goes along with the right to cross-examine. So perhaps the prosecution, after the defense's case, they may bring up a rebuttal witness. And, after they bring their rebuttal witnesses, the defense can bring theirs, so they can go back and forth with rebuttal witnesses for a while. That very rarely happens. But once they do that, then they rest their case. And during this whole process, the jury sits and listens. And it's very funny because we know from the studies of people's perception and attention and everything like that, that if you are passive, it's very hard to actually stay focused on the evidence. And knowing that some judges allow questions from the jury, so they allow them to pose questions, although they can't just raise their hand like we do in the classroom setting, but they can write them down and have the judge read them, or have them read, to the jury, by the foreperson or something like that. So that may happen as well. And then once that's done, then closing arguments happen, which, the same as the opening statement. The closing statement is a revisit to each side, to their theory of what happened in the case. So after all of this is over, then it is the jury's turn to render their decision. In order to do that, they have to be instructed. So juries have a much more limited role. So you think after the jury listens to all the evidence, the judge could just turn to the jury and say, okay, so what do you think? Do you think he's guilty? And then they give their verdict. But that's not actually what happens. Each crime has specific elements. So we talked about the actus reus and the mens reus. So the judge explains this to the jury in technical legal terms. So the jury will decide if so-and-so pulled the trigger. The jury will decide if so-and-so had the requisite mental state while they did this or that or whatever. So it's very specific. And sometimes this even includes answering questions. So the jury's role is actually very limited, and they don't decide in a quote-unquote organic fashion. They decide according to the elements of the crime with a very specific, choose-your-own-adventure style instructions laid out by the judge. So in jury deliberations, they often select a foreperson. So this is the person who is in charge of the jury, and they're the ones who deliver the verdict. And after they select their first foreperson, they'll begin deliberation. Well, that is where they all sit together and they go through the case. They go through the elements. They go through the jury instructions, element by element. And they are sequestered while they do that. If they're able to come up with a decision where they all agree, great. If they don't, it is what is called a deadlocked jury. So this is where the jury can't agree on a verdict, and they realize we can't agree, and we have to go in and tell them that we can't agree. Several things can happen. Number one, they may get what is called an Allen charge. And an Allen charge is basically where the judge gives them the jury instructions yet again, and then tells them to go back and try harder, basically. Or they can declare a mistrial. And a mistrial is where where the jury can't agree on a verdict, and they have to be all guilty or all innocent. And if they can't, a mistrial is when it is not possible to come up with a verdict. So then what happens is they have to start all over again. Typically, when a mistrial has been granted, oftentimes a prosecution does not follow up and try the person again unless there's a specific reason why they think they might be more successful. The last point on this slide is the issue of a jury pardon. Let's say, I'll give you an example of a time when somebody might give somebody a jury pardon. They have been convicted of an offense that is technically a felony, but the kind of thing that, is not really that big of a deal to many people. So, federal drug raid, somebody is found with a bunch of marijuana plants that they are growing, which is illegal under federal law, although most people think that marijuana is really not that big of a deal and it's legal under many state laws. But it's a felony charge under this particular federal law, and on top of that, there's a 3 strikes law in this state. So this would be the person's 3rd strike, and it would get them, life imprisonment. And it's pretty obvious that the person did it, and the jury finds them, however, not guilty because they don't think it's fair. They don't think the law is fair, and they don't think the 3 strikes is fair. This is called jury nullification. So that happens a lot. Sometimes the judge can step in and, keep the jury from doing this with more strict jury instructions, but it does sometimes happen. Okay, so the very last thing, so the jury has now decided and they have a verdict of guilty or not guilty. The verdict is read. So the jury will come back in, the foreperson will either read the verdict or deliver the verdict to the judge who will read it. And then there is the option of polling the jury, and this is where one of the lawyers can ask the judge to poll, or the judge could, on his or her own volition, decide to poll a jury. So if they think there might be something going on with the verdict, they will individually ask each person, is this your verdict? And the reason is because if somebody may go along with the group because they don't want, but they really don't think the person is guilty, and they say, is this verdict, do you think this person is guilty? Occasionally you will run up with a juror who says, no, I don't think they're guilty, even though they went along with the people in the room. So, you can have this with juries sometimes. They're sequestered for a long time, and the pressure to reach a verdict is very intense. And so sometimes you can have some pressure where people will just give in just to get out of there. And they'll sometimes do this when they really don't think that the person is guilty or not guilty or whatever. That's what polling the jury is for. And then once the verdict is read and the jury is polled, if they're going to be polled, there's a moment for post-trial motions. So once the, while court is in session, before the gavel goes down, the lawyers have a chance to, motion for a new trial, or that they can motion that a verdict be set aside if it's, they believe the verdict is something's wrong with it, it's obviously a result of prejudice or whatever. They make a post-trial motion. So usually they're denied, but almost always lawyers will make these post-trial motions because it's, as a matter of procedure, you have to make a post-trial motion in order to be able to appeal. So if you want to get that conviction thrown out later, you best make a motion for a new trial. Otherwise, if you don't make the motion, and even if it was unfair, they won't look at it. So, yep, that's the trial. It is, selecting the jury, impaneling the jury, presenting evidence and all of the rules of evidence that go along with that, the opening and closing statements, jury instructions, and deliberation. So that is chapter 18 for you, and have a beautiful day.